Welcome everyone to this week's installment of our Business in 2022 webinar. That's going to have to change to Business in 2023 webinar pretty soon. But welcome to all of you who regularly attend. We appreciate you being with us. We have another packed program for you this afternoon. Next slide, please. And as we always do, we are going to start off, next slide, with a COVID update. So here we are. As of yesterday, the case numbers appear to be going up, and we're going to talk in just a second about where they are going up. We're seeing a little bit of a spike. It's the first little spike we've seen in quite a while. The last significant spike obviously took place last winter, last December, January, February. So far, the numbers have crept up a little bit. We're seeing a 61% increase, but again, that's not that significant given the history. In January and February of 2022, we were seeing approximately 60 to 80,000 cases per day. So 6,000 daily average of 6,700 is still not that much, but it's something we will certainly keep our eye on. From our perspective, we are checking and constantly following the state to determine if it's going to make any amendments or alterations to policies or protocols. So far, that hasn't happened, but we will certainly keep an eye out for that. Next slide, please. You can see that the current spike is primarily in the southern part of the state, New York City, Long Island. These color maps are always very helpful for people like me who are visual learners. I can see that the darker colors are in the southern part of the state. You see there on the table that the cases went up in New York City, Nassau, Suffolk, Rockland, Westchester counties, Orange, Dutchess, all southern counties by significant amounts. So to those of you in our lower Manhattan and Long Island offices, stay safe. Keep yourself, try to avoid COVID for the first, hopefully, time. Okay, so that is our COVID update. No changes, I guess, to report is the significant information, although we are monitoring a spike. Next up, well, I should say first up, is Pete Jones. Pete has been on the webinar many times. Pete hosted the webinar for a long time, so you are all very familiar with Pete. I don't need to provide him with any introduction, although I am going to introduce his topic a little bit. We have seen quite a bit of movement, both on the federal and local levels as it relates to independent contractor versus employee classification. This is an important issue for all employers. As you determine whether or not you want to classify someone as an employee or try to classify them as an independent contractor. There are risks associated with that classification, and Pete is here to talk to us generally about implications of independent contractor versus employee classification. So Pete, welcome.
Thanks, Adam. It's good to be back here with everyone on the webinar. I thought I'd start off with a slide, that would just sort of highlight the scope of the issue and frankly, why it matters or why it may matter to each of you as you work through these issues. So the characterization of an individual who provides services, either as an employee or as an independent contractor, is going to affect a number of, pretty significant issues from an HR perspective. Obviously, we've got our wage and hour issues. That is how people are compensated. And in particular, we're concerned mostly with overtime compensation. If somebody's an employee and a non-exempt employee, independent contractors are not eligible for overtime. We'll talk in a little bit greater depth in a minute here about union organizing, the individuals' rights under the National Labor Relations Act. It's also going to affect you from a tax withholding perspective. If you get an IRS audit or a New York State tax audit, you may have some issues there that you need to deal with. Employee benefits are typically driven by these status. And that includes both the benefits offered by an employer, but also a number of statutory benefits, things that might be required under state law or federal law are typically driven by employee status versus contractor status. And then lastly, I just highlight here the workers' comp versus tort liability. When you think about what happens when somebody who provides services for you gets injured, if they're an employee, we're going to be looking at the exclusive workers' compensation remedy. If they're not an employee, could the employer, the utilizing employer, the person who is, or the entity that's receiving the services, potentially be liable, for under tort law for the injury sustained, which also typically opens up the door to broader and less predictable damages. So a couple other things to highlight quickly here before we move on. One is that the amount of control exercised over the work and the worker is sometimes driven by employee versus independent contractor status. I have had cases over the years where people have said, well, that person was an independent contractor, so we didn't feel like we could tell them what to do. And then subsequently, they're determined to be an employee, and the utilizing entity says, boy, that didn't work out very well. We didn't exercise any of the control that we would like to have exercised. And yet we've been found liable for them being actually an employee of ours rather than an independent contractor. So, sometimes that might influence your thinking or your analysis. And then there's also the idea of who bears the liability for the worker's actions. And that could include, if an employee commits an act that injures another third party, you may have responsibility as the employer for those actions. If they're an independent contractor, at least in theory, it might be their responsibility or the responsibility of their employing entity. So let's move forward here and jump right into the National Labor Relations Act analysis. This will give you a flavor for kind of what's going on. And I think if we walk through this in some detail, we'll get a sense for some of the other issues as well. So under the National Labor Relations Act, only employees have the right to unionize. And only employers can be forced to negotiate with unions. That's what the National Labor Relations Act does. It creates, the obligation to collectively bargain with a representative of the employees. And so, naturally, the question of whether somebody or a group of somebody's is an employee versus an independent contractor is a pretty critical question under the federal labor law. The NLRB General Counsel, that is really the person who sets the enforcement policy for the NLRB in Washington, has indicated that she would like to broaden the definition of employee to encompass more individuals who perform services, and then therefore have less independent contractors. And one outcome of that would be that there'd be more employees eligible for the protections under the National Labor Relations Act. And one of the things that the General Counsel is focused on is the changing nature of the workforce and whether or not that dictates some sort of change in the way the NLRB would analyze these issues. And so that's kind of the broad policy position here. Moving on, let's focus a little bit about what's actually afoot, and that is in December 2021, the board itself, the National Labor Relations Board, invited the parties in a case to brief whether the board should reconsider its standard for determining independent contractor status. And without getting too deep down into the weeds, there's a little bit of a pendulum effect going on here at the NLRB and some of the other federal agencies in terms of what's the standard under which we evaluate who's an employee and who's an independent contractor. So in this particular case, we're talking about the Atlanta Opera, and the invitation relates to union organizing for workers who provide makeup and hairstyle services. And the question there is whether they're employees of the opera or whether they're independent contractors who, come in and provide those services for people, but, are not actually employed by the opera. So the current laws set forth in a case known as Super Shuttle, and that that current board law applies the common law. Consider that really the historical test for independent contractor status. And there's a bunch of factors. They're not exhaustive, but the focus is really on the entrepreneurial opportunity and employer control. And if you think of those two things as potentially being on the opposite ends of the spectrum, the more the employer controls the services and how they're rendered, the less entrepreneurial opportunity there's typically going to be for the individual who performs those services. And therefore, they're going to look more like an employee, someone who works at the direction of the employer. On the other hand, if the person has tremendous opportunity in how they structure their business and how they provide their services, that's likely going to mean less employer control and more likely a finding that we're talking about an independent contractor. So anyway, the question here is whether the board is going to change the standard from the super shuttle position set forth in 2019. So as we can see, as we move forward here, the new test will likely make it more difficult for a worker to be classified as an independent contractor. One of the possible tests that the board could choose is the so-called ABC test, which has been adopted in California and in other places. And the factors there are, whether the worker is free from control or direction of the hiring entity, whether the worker performs work that's outside the usual course of the hiring entity's business, and whether the worker is customarily engaged in an established trade, occupation, or business of the same nature as the work performed. And sort of this is a little bit more focus on, there is a focus on the direction and the control, but there's also some focus on whether the worker's in an independent business or not, and whether the work performed is core to the employer's business or not. And so we'll see what happens here with the NLRB, but I think it's fairly likely that we're going to see a change in the standard and frankly how it's applied, and therefore more people who are deemed to be employees protected under the NLRA. So moving along here, we'll see what happens. It could be a big change for gig workers like Uber and Lyft drivers, industries that have been organized around an independent contractor model. And it could also affect, how things are interpreted under the FLSA, the New York labor law. They're not technically, neither of those would flow directly from a change in the NLRB standard, but these standards typically relate to each other, and the administrative agencies and courts often borrow from the analyses across areas. So let's go to the next slide, please, Brian. We'll for now, I think we want to keep a close eye on it. We probably need to look and see who's been identified as an independent contractor. And if it's a large group, I think you're going to want to analyze whether that is a group that might be susceptible, to unionization. The other thing to continuously evaluate is the degree of control and supervision that you exercise over the work, especially if that work is integral, core to the employer's business. So moving to the next slide, we'll talk a little bit about what's going on at the DOL here as well, because this is not simply an NLRB development. I went into that in a little bit of depth because I wanted to give people a flavor. But the DOL is also, the Federal Department of Labor has also issued a notice of proposed rulemaking. And what that rulemaking indicates is that they're considering revisiting the prior 2021 independent contractor rule to align a new rule more with the court's interpretation and base it on the so-called economic realities test. And what they're saying is they want to restore a multi-factor totality of the circumstances analysis, not really assign predetermined weight to those factors or a set of factors. In other words, see how weighty they are in each particular circumstance. And the things that the DOL has noted in particular and seems to be most focused on are the investment of the independent contractor, who's controlling and the opportunity for profit and loss. And that's, again, that idea of control versus entrepreneurial opportunity, and then how integral the work is to the employer's business. So you see a lot of the same themes going on here with DOL as we saw with the NLRB, and it's going to be some combination of the same factors, but really there's nuance in how these tests are applied will really indicate how how employees end up getting characterized. And again, under the NLRA, it's unionization and rights under the Act. For DOL, it's characterization, wage and hour issues, overtime eligibility, things of that nature. So these are important questions. Okay, so let's summarize this all for everybody. If we could go to the next slide, please, Brian. And Adam, I want to invite you back in because I know you had some observations on this as well. But some of the things as I wrap up here that I just wanted to suggest to folks is, number one, let's analyze where we're using contractors. It probably starts there. Okay. And one way to manage this is to consider the use of staffing agencies, especially if you've got large populations of workers who you're characterizing as independent contractors. If you're utilizing a staffing agency, then in fact you have an employer who's providing the labor. And so there is somebody who's doing the tax withholding. There's somebody who's taking care of the wage and hour issues. Now you may end up with some joint employer issues there and a little bit less control if you utilize a staffing agency, but it is at least one model to help you manage, various staffing needs, especially in the context of if you don't want to have, not everyone merits employee status. I think one of the questions you want to ask yourself when evaluating this is, why are you entering this relationship and why are you characterizing it this way? It's sometimes the case that people say, yeah, I don't know, that's how we've always done it, but there's no real reason to do it this way. And in that context, you may want to reconsider whether you characterize people as an independent contractor or an employee. The other thing you might think about is outsourcing versus internal use. This is not applicable to everybody, but where work is performed on site under the supervision of the employer, there's that control element. And that tends to be one of the strongest factors here. If there's something that could be provided to you on a turnkey basis from the outside, that might be, an option for meeting your needs while at the same time avoiding, these kinds of issues. If you're involved in something that is, sort of dependent upon the gig economy, I think you really have to keep your eyes on this. The whole model of the gig economy was that people could pick up work and not pick up work, and that they had the profit and loss in their control. But these potential standards can certainly threaten whether that model is going to be permissible, at least in that form, without adjustment. And I'm thinking here about the pendulum effect. I mentioned it at the NLRB, but we're also seeing it at DOL, with DOL saying, well, maybe we should have a new rule because we think that, frankly, the past, administration at the DOL got it wrong. So, Adam,
Well,
yeah, go ahead.
Yeah, thanks so much. I will point out a situation that I've encountered a number of times with clients, and that is somebody that they've classified as an independent contractor. They've had an independent contractor agreement, so they thought that that was enough. So my first word of warning is, just because you have an independent contractor agreement doesn't mean that the individual is properly classified as an independent contractor. But what can happen is that person leaves, files for unemployment unbeknownst to you. New York State unemployment sees that this person is not an employee. You haven't been collecting any taxes. You haven't been paying for workers' compensation insurance. And then that will prompt an investigation into you and your business, and potentially an audit of all of your employees, who you're classifying, who you're not classifying as an independent contractor. So I would say this is a very, very delicate issue. And to the extent you are using independent contractors, review those relationships. Contact an attorney if you have any questions. Make sure that you're on solid footing, that these are really independent contractors, and you're not going to get bit by a federal or state agency who's going to come back and say, wait a second, you classified these people wrong. You owe us a lot of money, both in comp, insurance you should have been paying, taxes you haven't been paying. So be very careful. That's my word of warning. All right, the next topic actually segues perfectly because New York City has recently enacted a new law called the Earned Safe and Sick Time Act. And here to talk to us a little bit about that act and its implications is Paige Carey. Paige is an associate trainee in our New York City office, and she has been following this statute closely. So Paige, welcome.
Thank you, Adam. So just to give a little bit of an overview of this proposal to amend the Earned Safe and Sick Time Act, I refer to it as the ESSTA throughout, just for short. But so this proposal was introduced on August 11th of 2022 by the New York City Council. And really what this would do overall would amend the definition of employee under the Act. The proposal would allow for certain independent contractors to qualify as employees and receive benefit coverage under the Act. And it would require hiring entities to engage in a detailed analysis of individuals providing service for the hiring entity to determine whether or not they are independent contractors or employees, which, as Peter mentioned, does have some significant implications, whether someone is defined as an independent contractor or an employee. So the best way to break up this proposal is to look at it in two distinct categories. There's two separate analyses depending on which category someone falls into. So the first category is individuals providing non-professional services, and then the second category is individuals providing professional services. And you can go to the next slide, please. So for individuals providing non-professional services, and then next slide, please. The proposal amends the Act's definition of employee to include a presumption of employment, which is significant because it falls in favor of the individual who the hiring entity is trying to determine whether they are an independent contractor or an employee. And there's two separate ways a hiring entity can overcome this presumption. They can either show that an individual is an independent contractor, or they can demonstrate that an individual is considered a separate business entity as defined by the proposal. Next slide, please. So for proving that an individual is an independent contractor, these factors that are in the proposal are actually the same ABC factors that Peter mentioned earlier. So a hiring entity can show that the individual is free from control and direction in performing the job. The service must be performed outside the usual course of business for which the service is performed, and the individual is customarily engaged in an independently established trade, occupation, profession, or business that is similar to the service at issue. And if all of those factors are met, the person is considered an independent contractor and the individual is not afforded the benefits under the ESSTA. Next slide, please. So for the second way to prove that an individual is not required to be given benefits under the ESSTA, a hiring entity can prove that the individual is a separate business entity. And this requires proof of 12 criteria that are listed within the proposal. And I won't run through all of them just for sake of time, but if successfully asserted these 12 independent criteria, the separate business entity is then categorized as its own hiring entity, independently subject to the proposal's provisions. So really then the analysis would fall onto the new hiring entity to determine whether the individual is considered an independent contractor or an employee. Next slide, please. So for the second category of professional services, the following services are considered professional services, and this is within the proposal itself. These are, as you can tell, more art-based, more creative-based positions. So for these types of positions, there is actually not a presumption of employment. Next slide, please. And this is pretty significant because it falls a little bit more in favor of the hiring entity. However, the hiring entity attempting to show that an individual providing professional services is an independent contractor still has to prove the existence of 6 enumerated criteria that are listed within the proposal. And then the second step after these 6 criteria are proven, the individual's employment status is then contingent on a balancing test of 11 factors. None of these factors are determinative. It just depends on whether the factors weigh in favor of employee or weigh in favor of independent contractor. And these factors are largely focused on control. They're the common law factors that Peter mentioned earlier. Next slide, please. So just a couple of concluding thoughts. So we're still waiting to see what happens with this proposal. As of now, the definition is not this expanded definition under the ESSTA. It's still a narrower definition of employee. But if the definition is expanded, it will become harder to prove that an individual is an independent contractor exempt from ESSTA benefits. And a couple of employer actions to keep in mind if this proposal is passed. Employers will be required to update employee handbooks and collective bargaining agreements in accordance with the proposal's definitional changes. And then it's also possible that employers would be strongly encouraged or even required to document their analysis of these individuals and retain such documentation. We've seen this happen in other New York City laws, so just important to kind of keep a pulse on that as well. And that wraps up the proposal.
Paige, thank you so much. I think that your presentation is further evidence that to the extent you're considering using an independent contractor, we see different definitions in New York City versus New York State versus the federal government. So make sure you're consulting with one of your favorite bond attorney on that issue.
Absolutely. Thank you.
All right. Next up is Seth Gilbertson. Seth has been on the webinar many times before. Seth is here to talk to us about some updates. Seth, take it away.
Thanks, Adam. Yeah, we're going to be switching gears here away from some of the labor and employment stuff and focusing on independent aid to colleges, direct aid to independent colleges and universities in New York State. This is an issue that I believe I spoke to this webinar about back in August or September, when every independent college, private independent college and university in New York State had to submit a faculty diversity improvement plan as a precursor to being eligible for what we commonly refer to as Bundy aid. Recently, there have been some changes. Can we go next slide, please? Recently, there have been some changes set forth by the New York State Department of Education in the higher education data system, which is where the guidance on this kind of thing is generally provided. Interestingly, these changes just came about on November 21st. As I just said, the original faculty diversity plans were to be submitted by September 20th. So we're about 2 months behind when they've been submitted, and now they're providing guidance. I'll talk about this in just a minute, but I think this is we're gonna interpret this, at least at this time, as forward-looking guidance. These faculty diversity plans are meant to last 2 to 4 year increments. So we're going to be looking at it going forward. That being said, we do want to start preparing for those future submissions that we're going to have to make. I'm going to talk about how we're going to prepare for that now. The changes in the guidance are really sort of twofold. One is that they give specific language that we are supposed to insert in a goal. And those of you who have participated in submitting the faculty diversity plans know there are 3 goals that each institution is supposed to submit. If one of those goals is based upon data that the institution has already submitted to the state education department, then that's all you have to say. So those are kind of the easy ones. I'll show you an example of that in just a minute. The more difficult ones are where goals are more unique and rely on elements of diversity, aspects of diversity that are not captured in the general data that is already submitted to the state education department, which really focuses on race, ethnicity, and gender. So next slide, please. So here's one of the easy ones I just talked about. Here, if one of your goals is something that does refer specifically to race, ethnicity, or gender, in this case, I used increasing full-time faculty, proportion of full-time faculty who identify as female. That would be something that's captured in the data that you've already submitted. So we're just going to say that. See faculty diversity plan data. It's something that you're going to submit along with your goals already. So that's a fairly easy one. And you can revise that in your plan now. And just so that you're ready next year when you submit your plan, you'll be able to show any kind of incremental growth in the area of that goal. You're not going to submit it right now because we've already submitted them in September. Allocations of aid have already been made. I don't foresee the state education, could be wrong, but I don't foresee state education department coming back and asking for revised goals based upon guidance that just came out now. I think it's more likely that they'll look to see that in future year submissions. But if they did ask for it and you are revising your goals now, the way that you've described your goals now, you'll just be able to give it to them. It'll be very easy, and that will set you up for future success. So I'd say revise your plan now, but do not submit it. And part of that revision is going to be just citing to the data that you've already submitted if that data is available. Or, next slide, please. Creating the data information informing the goal section to more closely align with the current guidance, which basically specifically says that you should include numbers if you have them. State education department seems to assume that you're always going to have some numbers, always going to have some data. I don't think that's always going to be the case. I've seen a lot of these plans, and many of the goals rely on data that has not yet been collected or submitted. I think that's okay. Nothing in the law requires you to have data prior to having the goal. So I think that's the second one here, where you basically state data collection began this year. We just came up with a goal. We're coming up with the data now. We're going to use the data that we collect this year as the baseline data for future years. You could write 0, but I think that's kind of pointless because the answer is often not going to be 0. It's going to be some number that you haven't determined yet that then you're going to try to improve on over the next 2 or 4 year increments. And that's all I have. Thank you.
Seth, thank you so much. For those of you who are in higher ed, Seth is a wealth of knowledge on all things higher ed related. So please feel free to reach out to Seth with questions about what he just talked about or anything else.
Thanks, Adam.
Oh, okay. Last but certainly not least is Teresa Rusnick. And Teresa is here to talk about and to give you all a review on New York's paid sick leave law. This law caused angst among employers for a very long time. Teresa is the go-to person on the New York State paid sick leave law and is presented on this law on this webinar over the past 2.5 years several times. We thought it would be helpful as the year is coming to a close and a number of you will be reloading your sick leave banks to provide an overview of the sick leave law requirements and to address any issues you might have. So Teresa, thank you for being on again. Welcome.
All right, thank you, and good afternoon, everyone. So as Adam said, I'm talking about New York State paid sick leave. It is one of my favorite laws, and it's certainly something I'm happy to discuss with anyone who wants to discuss it with me. As a reminder, kind of a review of the basics, the amount of leave that you have to give depends on your size as an employer and to a certain extent on your income level. So I've laid that out in the chart there. Most employers are probably going to fall in the latter of the two categories, the 5 to 99 employees or the 100 or more employees. And so they're going to be giving 40 or 56 hours of paid sick time to their employees. They can do that either by having the leave accrue at a rate of 1 hour for every 30 hours worked, or they can front load all 40 or 56 hours to the employee on a calendar date on a yearly basis of their choosing. The number of employees is determined by counting the highest total number employed concurrently nationwide at any point during the calendar year. So you have to count your seasonal employees, even if they're only with you for a short time. This was part of the guidance that came out and part of the final regulations that came out last year. So if you are one of the employers that kind of teeters in the 98 to 99 range, and you might be hitting the 100 when you hire a seasonal employee or two, or you hire someone for a short time, know that that's likely pushing you into the 56 hours bucket and out of the 40 hours bucket. Next slide, please. One of the most common questions I've gotten and continue to get about paid sick leave, and something that I always have to reconcile when I'm reviewing handbooks or any kind of paid time off policy is, how do we incorporate paid sick leave with our existing paid time off? The majority of employers already give their employees some type of paid time off, whether that be vacation or personal time, or even just regular PTO time that they then had to incorporate paid sick leave into. So New York State said that an employer is not required to provide additional sick leave if the employer has adopted a sick leave policy or time off policy that provides employees with an amount of leave which meets or exceeds the requirements of this law and satisfies the accrual, carryover, and use requirements. And really the rub with that is in the last sentence or the last section of that sentence, satisfying the accrual, carryover, and use requirements. So you can integrate paid sick leave into your PTO or your existing leave policies, but you need to make sure that that complies with the carryover, accrual, and use requirements of New York State paid sick leave. So what does that practically look like? Usually you would integrate the amount of sick leave, make sure you're meeting the amount and use increments first. You'd put in the use for New York State paid sick leave into your PTO policy. And then you'd have to deal with the question of carryover, which I think is my next slide. So let me go to that. Yes, the question of carryover. This continues to be the single most frustrating aspect of New York State paid sick leave. I continue to have to explain this to employers, and I don't blame them at all. This is something that New York has done a very bad job at explaining why they've taken the rationale that they have. And so for those of you familiar with what I'm talking about, you know that New York State has said that sick leave has to be carried over into the following calendar year, and that you can't cap the amount of carryover that an employer can, or that an employee can carry over. So they could carry over 50 hours or 100 hours or 2 hours or however much time they haven't used in that calendar year or in prior calendar years. So carryover is, as it's properly stated in the guidance, unlimited. However, New York State has also said that even though carryover is unlimited, employers can cap the use of paid sick leave at either 40 or 56 hours per year, depending on the size of the employer. So if you have under 100 employees, you can cap it at 40. If you have over 100 employees, you can cap it at 56. Now, for those of you following what I'm saying, it's nonsensical, right? Because you have an employee who could be rolling over a lot of time that they can't actually use. So you end up having an employee who looks like they might have hundreds of hours of paid sick leave or PTO if it's combined with paid sick leave, but they can only use 56 hours of it, or they can only use 40 hours of it, or they can only use a certain cap around or above those limits. And so it continues to be a very difficult thing for employers and employees to grapple with. I thought that this was something that New York State would change in its final regulations. Those came out just about a year ago, and they did not. In fact, they doubled down on this concept that even when you front load the leave, you still have to allow for unlimited carryover. Their rationale for doing that, I don't know that I've heard one that I understand or agree with. Other states do this differently, especially in the front loading aspect of leave and carryover. But in New York, there is still unlimited carryover and you can cap use. I've had employers take contrary positions to this, and kind of risk what might happen if the DOL came after them or if they were in an audit. I've had employers who have resigned themselves to explaining to employees that this is what the landscape of carryover and use look like. And I've had employers everywhere in the middle. So I understand this continues to be a very frustrating aspect of New York State paid sick leave. Next slide, please. So some other important points. Other laws let you impose a waiting period for accrual or use of leave. New York State paid sick leave does not. The accruals or the front loading starts on the very first day of employment, and you cannot make them wait to use their leave. Seasonal employees who maintain an ongoing relationship with the employer maintain their leave accruals through their breaks in employment. That's a pretty vague statement to me, but I think it essentially means that if you have a seasonal employee who has every expectation of being rehired, their paid sick leave balance gets restored at that time. Employers may have a policy that allows employees to donate leave to other employees as long as making the donations is voluntary. I think that makes sense. So for those of you that have policies allowing sick leave donation, you can do that as long as you ensure that it's voluntary. Next slide. Paid sick leave does not need to be paid out at termination or resignation of employment, but, and this is very important, if you are not going to pay it out, your policy needs to be very explicit on that point. Otherwise, New York defaults to the position that the leave must be paid out. So you don't have to pay it out, but your policy needs to say that. Same thing if you're going to condition the payout upon some other type of requirement, like we're only going to pay out paid sick leave if you give us 2 weeks notice, or we're only going to pay out paid sick leave if you resign. And if you're terminated, we're not going to pay it out. All those conditions are fine, but they need to be put in your policy and made explicit. Otherwise, again, New York's default position is that the leave has to be paid. Employers can front load leave for part-time employees, but they still have to track the hours. So if you have a part-time employee and you want to front load their leave at the beginning of the year, you're free to do that based on a rough estimate of how much you think they're going to work, but you still have to track their hours, because if at any point in the year they are or could be accruing at the 1 hour for every 30 hours worked rate faster than what you front loaded them, you have to go back and reconcile their leave. And then finally, this is a question I get a lot on medical documentation. Employers can require medical documentation for use of paid sick leave, but only after an employee has been out for 3 days. If they have been out for a shorter period of time than that, the employer is stuck and cannot require medical documentation to certify that absence. So there's a lot more that could be said about paid sick leave. Like Adam said, I've done several webinars just on paid sick leave, and then I think one particularly memorable one where I did paid sick leave and New York COVID law together. I must have been ambitious that day. But for now, I think I'll cap it there and turn it back to Adam.
All right, Teresa, thank you. There are quite a few questions, as you can imagine. I think we have time for one or two of them. All right,
Okay.
so I'm not going to be able to get to everyone's. I apologize, but there are a few that I think we can address. One of the questions is, have you seen any audits by the Department of Labor of an employer sick leave policy since this went into effect?
I have not. No, I've been involved in other New York State Department of Labor audits where they've, addressed things like wage and hour and frankly, independent contractor to our earlier speakers, but not this aspect of it. No, I don't know if you've seen differently, Adam, but I haven't seen it.
I haven't seen any either. Okay, so a next question. For employers that have a PTO policy that incorporates sick leave time, does that require providing the same job protection for using sick leave to all PTO hours available?
It does if you're not going to distinguish within your PTO policy what is sick and what is otherwise PTO. So you can characterize it all as PTO and then track how much that PTO is actually used for sick time. At that point, some employers usually just separate them out and do two separate policies, but otherwise you'd have to be careful about which of the PTO is used for sick time, because that's going to get protections that the regular PTO wouldn't.
We got a couple of different questions about if an employer pays out unused sick time at the end of the year, then that wouldn't carry over. Is that right?
Well, so the payout is, Adam's smiling. So the payout is a tricky issue, right? So New York State has said that the leave needs to carry over. I believe you can do a voluntary payout, but you can't require the payout of the leave.
Okay. I think that is all we're going to have time for today. I appreciate everyone being here. If you have more detailed questions for Teresa, she's certainly available. And her contact information you can see here on the screen, as well as the contact information for everyone else, including myself. If you have questions, feel free to reach out to any of us. Thank you so much for being with us today. We will see you again next week.